everybody. Good morning and welcome to class number 9 of our 2025 virtual HOA and Condo Academy. Today is Tuesday, September 16th, and welcoming all of you as you're joining our presentation today. I'm going to give just a few seconds for attendees to enter the Zoom and to get settled here this morning, and also to get this broadcast on Facebook Live. Welcome to class number 9 of our 2025 virtual HOA Condo Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. As you may know, if you've attended prior classes with our firm, I've represented HOAs and condominiums in the state of Arizona for over 28 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. Our session today is going to provide an easy-to-understand overview of the new legislation affecting HOAs and condominium boards. We're also going to address current insurance challenges facing HOAs and condominiums, and offer practical tips on preventing crime and limiting liability for your associations. As always, we will have question and answer at the end of the presentation. I will conclude the main presentation hopefully right around 12 o'clock, and then we'll move right into questions at that time. Due to the large volume of questions we receive, please note that there is one question per attendee. If you're joining us on Zoom, please be sure to submit your question in the Q&A box. If you're joining us on Facebook Live, please type your question in the comments section. Okay, we're going to start out today with a poll. Which city do you reside in? Is our first question for today. I always like to know which cities are represented when we're teaching these classes for the different neighborhood services. So I would really appreciate it if all of you would respond to the first question. And then the second question is also let us know what your role is so that we can tailor the class today to best fit who the audience is here today. And while we're waiting for those results to come in, let's go ahead and get a head start on our presentation for today. Okay, so today we're going to be talking about the new legislation first. The Arizona legislature began their 2025 session in January of 2025. And they adjourned on June 27th, 2025. So just over 6 months of the legislature was in session in 2025. It was an unusual year in that there were a lot of bills that were introduced pertaining to HOAs and condominiums, but ultimately only 4 bills that directly impact HOAs and or condominiums were passed into law this year. These 4 new laws, which we're going to talk about here in a minute, will become effective on Friday, September 26th. So in like a little bit over a week. Additionally, there were 3 other bills that were signed into law that may be of interest to our clients. So we're going to briefly talk about those today as well. Those of interest bills will also become effective September 26th unless otherwise indicated. Okay, so let's get right into it. The 4 bills that you need to be aware of that passed in this year's 2025 Arizona legislature. And again, these bills will go into effect on Friday, September 26th. Senate Bill 1039 talks about recording of open board meetings. This bill applies to both planned communities and to condominiums. And it just requires that if a board is going to record a meeting, it's becoming very commonplace because a lot of boards are having their meetings now on Zoom or hybrid with Zoom. So if the board is recording their meeting in your planned community or condominium, and that meeting is open to the members, so this does not apply to executive sessions, the board shall keep a copy of the recording of that meeting for at least 6 months and make the unedited recording available to any member on request. So just kind of a change in protocol. If you are recording your open board meetings, you must, as a board, you must keep that recording for 6 months. And if an owner requests to see it, they're entitled to see an unedited version of that recording. Okay, the second law talks about political signs. It's Senate Bill 1378. This applies to both planned communities and condominiums. And this bill changes the definition of political signs to include a sign or a flag. I think this is just kind of a sign of the times bill. As you know, in our most recent past 2 presidential elections in our country, we saw political signs in the form of a flag. And I think our legislature is just now, including that, directly, or being more specific about the fact that a flag can also be a political sign. So next election cycle, which will probably be coming up here in November, it's kind of uncustomary, in my opinion, to see political flags for elections that aren't national elections. But, the next presidential election will probably see this come up again. And if an owner wants to fly a flag that is a political sign, that will be allowed as long as the provisions pertaining to political signs are abided by. And those different provisions include like how soon you can put the flag up and when you have to take it down after the election. Okay, the next bill, this is kind of a little bit more of a controversial bill. This is Senate Bill 1494. This only applies to planned communities, so this does not apply to condominiums. And this is going to change a little bit the foreclosure process that our clients or associations in general, planned communities in general, will be subject to this new law. And it's going to make it a little bit more difficult to foreclose if you're an association and you're foreclosing on an owner for not paying their assessments. So the prior law allowed us to foreclose. There was like some benchmarks that needed to be met to foreclose previously. And those benchmarks were that you had to have, 12 months, of the delinquency in assessments only for 12 months. And then the dollar amount was for $1,200 before we could foreclose in assessments only. And so they made it a little bit more difficult in that now we cannot foreclose until the assessment period that's unpaid is 18 months. Or they've reached $10,000 that's owed. So probably for most of our clients, 18 months is going to be, the threshold, because $10,000 is going to be quite high for planned communities. And so just something to think about if you're on the fence about foreclosing on somebody, between now and the date that the new legislation is going to go into effect, Friday, September 26th. You may want to file your foreclosures before Friday, September 26th, so that you don't have to comply with the increased difficulty to foreclose based upon this new law. So again, going to be a little more difficult for planned communities to foreclose. We'll have to wait either 18 months of unpaid assessments or $10,000 that's owed. The next bill is, and again, that not apply to condominium. The next bill is House Bill 2322. This is going to be kind of a limited, but this does indicate that it talks about condominium. It applies only to condominiums, House Bill 2322. And it addresses assessments on commercial versus residential structures in a condominium. Also included in this bill are some definitions of commercial structure, common expenses, and residential structures. So just gives us some guidance if you are a commercial condominium versus a residential condominium. Okay, some other bills. Those are the 4 big ones, and probably the ones, that you're going to see the most on that are going to be, if you're a planned community, it's going to be a little more difficult to foreclose, as we talked about. If you're video or audio recording your open board meetings and your planned community in a condominium, you have to keep that recording for at least 6 months and make an unedited version available for your owners if they request it. And then, of course, the political flags are going to be treated like political signs going forward. So, considering how many bills were introduced this year, the fact that we only have those 4 is actually probably pretty good. I wish the one that I wish did not get passed this year is the one with the foreclosure, additional restrictions on foreclosure, because I do think it's going to give homeowners who don't want to pay their assessments, a longer period of time that we have to wait. And it may make it more difficult to collect on those debts. Okay, what are some other bills that just FYI we want you to know about, kind of indirectly related to associations? Senate Bill 1022, the small claims court jurisdictional limit was raised from $3,500 to $5,000. So if an individual, some HOAs and condominiums are filing in small claims court, maybe their management company is helping them with that. Now the jurisdiction is up to $5,000. So that means you can sue for up to that much towed once the effective date of this new legislation goes into effect. Senate Bill 1070 talks about tax deed land sales and procedures. This would allow a county board of supervisors to sell real property in the county held by the state by tax deed to the owner of a contiguous real property that is used for commercial, agricultural, or residential purposes. It also authorizes the county board of supervisors to sell similarly situated real property to a homeowners association if the property is part of a common area maintained by the homeowners association. So, if the taxes aren't paid, it might be kind of like a recovery effort for the HOA to get their common areas back if they're sold. House Bill 2928 talks about accessory dwelling units and requirements. And it addresses the regulation of accessory dwelling units by municipalities and condominiums. And so, if you're having issues with ADUs, this law is something that you probably want to take a look at. Most of our clients don't have accessory dwelling units, so I'm not going to go too deep on it, but that's House Bill 2928. Okay, let's hop right into our main presentation for today. Oops, can't forget the poll. So we have our poll results back, and it looks like we have really good representation from all of the different neighborhood services departments that we are teaching these classes for today. So we have 2% from Avondale, 10% from Chandler, 2% from Glendale, 4% from Goodyear, 40% from Mesa, 2% from Peoria, 10% from Phoenix, 16% from Scottsdale, 10% from Surprise, 4% from Tempe, which is just a great turnout. Every single city that we're teaching the classes for here today have representation, which is amazing. It looks like at the time of the poll, we had about 94 people in the class. I know that that doesn't include our Facebook Live viewers. And I know a bunch of you have joined while we were talking about the new legislation too. Let us know your current role. So we have 59% of you are board members, 6% are managers, 30% are interested homeowners, and 6% are other. So great representation today. Again, kind of as always, we're seeing a lot of board members who are joining these classes. It's basically 2-to-1 board members versus homeowners, but we're really happy that the homeowners are here too, listening, learning how they can make their communities better and making sure holding their boards accountable to make sure that they are doing what they're supposed to be doing and following the law. Okay, let's talk a little bit about insurance. Insurance has been a really hot topic for boards the past few years. I think we can all agree that probably the hottest part of that topic is that premiums are going up and associations are struggling to find insurance. They're struggling to meet the expense to pay premium increases. And we're receiving calls at least once a week from clients saying, hey, we just got our renewal notice and our premium has doubled, or, in some cases, gone up even more than that, or even worse, the insurance company is just refusing to even write a policy for that particular association. So rising insurance costs are definitely a hot topic right now in our industry. New data from CAI's Foundation for Community Association Research is underscoring what many homeowners boards and community managers are experiencing. According to the Foundation's Insurance Coverage Trends SNAP survey, 91% of community associations experienced an increase in insurance premiums. 17% saw increases exceeding 100%. 23% shifted to surplus line carriers due to lack of traditional insurance carriers. 20% reported losing access to one or more insurance carriers. And many reported rising deductibles to kind of counterbalance the increase in the premiums. decreasing their limits, and limited market availability in disaster-prone states. California, Florida, Texas, North Carolina, Arizona. A lot of these states are experiencing these issues. While these trends vary by region and the different types of properties that are out there in the United States, it's clearly a message is being sent that there are now new financial pressures being placed on boards and homeowners when combined with the association's responsibility to maintain the infrastructure, fund reserves, and meet lending compliance requirements. And so this is a problem that many associations are facing. Okay, let's talk a little bit about, what are some pivots that associations have if you're running into a situation where the premium increase from your current carrier is too high? Well, you should definitely be shopping the market for your insurance. Now, what you need to know is that 60 days before your insurance policy is renewed, you will receive a notice of renewal or non-renewal. And if you're receiving a notice of non-renewal, you definitely need, your management company, if you're managed by a management company, should be notifying you immediately that this has occurred, because you need to be very agile and pivot right away if your current insurance is not being renewed. You may want to reach out to your legal counsel. You definitely want to talk to your insurance agent and see what their recommendations are to help you through that difficult, time. What about if your premium goes up significantly? Again, shop the market. You may want to think about playing with your deductibles, have a higher deductible so you're self-insured as an association up to a certain dollar amount. Make sure that you are not changing the insurance coverage that's required by your CCNRs, or if you're a condominium, that may be required under the Condominium Act. Again, reach out to your trusted advisors, your insurance agent, and your legal counsel to help you navigate that. And you got to do it right away as soon as you get that premium increase notice, which is typically about 30 days before it's due. Some associations are doing amendments to their CCNRs to change insurance responsibilities from the association to the owners. That's very difficult to do, and in light of recent case law, that may be impossible. You may need 100% approval of your membership to do that, but it's something that, as a board, it's a consideration, and you should talk with your legal counsel about that to see if that's something that might be able to help your association. Not having insurance for your common areas is something that is not an option from my perspective as legal counsel for associations. And so, most association CCNRs have a requirement to carry insurance. And so just saying, well, we just won't carry insurance is not a good business decision and can result in really severe liability for your association. One other trend that I've seen recently in condominiums is that insurance companies are becoming more involved if there are problems in terms of maintenance problems or infrastructure problems in your community. We've seen several associations that have the insurance company mandating that the associations, and this would be like in a condominium, mandating that the associations take certain actions in order to have continued insurance coverage. So that's kind of another new trend that we're seeing. So, for example, sometimes the insurance company will send out a representative to your property, and they're going to do an evaluation of, the current condition of your property prior to a renewal of your insurance policy. And they may come up with a laundry list of things that you need to repair or bring up to code before they will renew the insurance policy. So that's a trend that we're starting to see more and more with associations. We have a great cheat sheet, and there's also a great article that was written by CAI, Community Associations Institute, national think tank helping associations, condominium planned communities, board members, and homeowners navigate issues that face community associations in the United States. So the CAI article is on navigating insurance pressures in today's condo market. We're going to be sharing that with you. here right now. And then we also have a great cheat sheet on insurance, protecting the association and the board that our firm has put out. We can find that on our website at mulcahylawfirm.com, or we also will be sharing it with you on Zoom and Facebook Live today during this presentation. Okay, so we talked about the big hot problems, the trends right now that are facing associations on insurance, premiums going up and not being able to get insurance, etc. Let's now turn and do a little bit of a overview of what exactly insurances an association may be required to carry, and any special information about insurance that would be helpful to your board. Okay, quick little insurance overview. Obviously, protecting the community association and the board requires a close look at insurance coverage for your association to prevent coverage gaps that become obvious after there's a problem, right? And so, just some information about what types of insurance there are out there for associations. Let's just start, right from the top. So I would not serve on a board unless the association carries directors and officers coverage. It's often referred to in slang as D&O, or directors and officers, or E&O, errors and omissions insurance. This typically covers the board of directors. It may also extend to committee members. Common claims against associations include the board's failure to, follow the governing documents, or maybe they're not maintaining something, or maybe the architectural committee makes a decision that an owner is aggrieved about. And so maybe somebody thinks that the board has breached their fiduciary duties to the association or breached the contract, the CC&Rs. Occasionally, we'll see Fair Housing Act discrimination cases filed against an association. And so basically what the D&O or E&O coverage does is it's a policy that the association carries. And basically what happens is it includes indemnity coverage for the cost of defending actions that are filed against the association and individual board members. And oftentimes it depends on how the policy is written, but, it's going to provide insurance defense in terms of a legal attorney will be assigned to by the insurance company to defend the association or the individual board members. The individual board members are named. And again, the most typical lawsuits on this would be that you have a homeowner that's aggrieved about something, and they are filing a lawsuit against the association and maybe the individual board members, and they're claiming that the board didn't do something that they should have done, or that they did something and they did it improperly. And if a lawsuit like that is filed, having this insurance coverage, the D&O or the E&O coverage, will provide the association and the board with legal defense in the form of an attorney that's assigned by the association's insurance company. So, no one wants to serve on a board if they think they're going to have personal liability for, being a volunteer board member. So this is another level of insulation, in addition to the indemnification provisions under state law and indemnification provisions that are typically under an association's bylaws to indemnify an association's board member in the event that they're sued for taking action as a board member. So a lot of times I'm asked, how much does a D&O policy cost? Well, it depends on, what type of coverage you're getting. Sometimes associations have $1 million, sometimes they have $5 million, sometimes they have $10 million, depending on, how large your association and what issues are facing your association. We've seen, for the $1 million policy, premiums are typically in the range of $900 to $1,500 a year. Okay, let's switch gears and talk a little bit about property insurance. Property damage claims are more common, frankly, than D&O claims. I receive an email every morning from a source that, we pay to get these emails from. And basically what it does is it tells us the name of every lawsuit that was filed in Arizona in the previous day. And so I have a pretty good pulse on what the issues are that are facing associations right now, legal issues. because every day we pull out the cases specifically that apply to associations, and we kind of take a quick peek at, okay, what are the most common lawsuits that we see? And so we typically do see a lot of property insurance type issues, where an owner trips and falls on the common area, or, there may be damage to, an owner's property. And so in our experience, property damage claims are actually more common than D&O claims based upon, the lawsuits that we're seeing filed in Superior Court in Arizona. What you definitely want to be careful about on the property insurance is you want to make sure that you have enough insurance based upon what your governing documents state. And so talking with your insurance agent and your legal counsel to make sure that you have adequate insurance based upon what your documents or what state law may require is very important. When you're new to the board, something that you want to be thinking about is when the renewal comes up, that's a great time to invite the insurance agent to your board meeting and ask them to review the provision in your documents and to also then review what your current existing insurance is and make any recommendations with regard to the property insurance to make sure that there are no gaps in coverage. Or also make sure that if there are specific things, like if you're required to have guaranteed replacement costs, are the numbers set, adequately based upon the current value of your association. And so that could result in you may need to have your property appraised, or, maybe the insurance company will provide that information to you. And so property damage claims, like I said, are very common, and you need to have property insurance in addition to the insurance that's going to cover the board, maybe any committee members, the D&O insurance. The next type of insurance that's important for associations to have is Fidelity Insurance. Fidelity Insurance covers theft and fraud of association funds, basically. And Fidelity Insurance should be issued in the association's name with the property manager obligated under the association's policy. By structuring it in this manner, the insurance will cover a theft by the management company principals as well as their property managers, in addition to board members. The management company usually has its own Fidelity Insurance, but that's going to typically cover the property manager only. It doesn't always cover thefts perpetrated by the management company's, principals or owners. So basically what Fidelity Insurance is it's theft. It's insurance against theft and fraud of your association's funds. So, for example, let's say that you have a self-managed association and the general manager for the association, it is discovered that the general manager has been taking association funds. And after, going through the procedures that you would need to terminate that person and not giving them access to any of the association's funds, there'll be an evaluation. Okay, how much money did this person really take from us? And once we have concrete evidence about, how much money was embezzled, we should be notifying our insurance carrier right away if, we discover that there's potentially fraud or embezzlement by a board member or by, your property manager. Then we go to the insurance company and provide the information to them, and then they may pay out under the Fidelity Insurance. And so this is an added layer of protection in the event that, manager or board member, or maybe even the management company principals that are managing your association, if there is theft of fraud or embezzlement of your association funds. So again, kind of the three areas of insurance, just as a quick recap, that your association really should have are directors and officers insurance, D&O policy, property insurance, and then Fidelity Insurance or Fidelity bond. One little practice pointer, usually there's not that big of a jump in how much more it goes up to have a little bit more coverage. So it's something you'll want to evaluate, like the difference between a $1 million and a $5 million D&O policy might only be a couple $100. It might be well worth, the money spent. especially if you're thinking about something that's controversial, like passing a special assessment, or you're getting ready to do a general master plan for your community and you know it's going to be controversial. Kind of the same analysis on Fidelity Insurance. Most policies that we see, there's something like 50 grand in Fidelity Insurance. So you really want to look at what sort of cash on hand you have on your accounts, and do you have enough coverage to protect you in the event that there is theft, fraud, or embezzlement of your association's funds. And you should ask your agent, hey, can you give us different price points for, how much our premium would be for different amounts of Fidelity Insurance. Let's see. Again, how much is enough? Be sure that you're checking your association's documents to make sure that you have the required coverage pursuant to your association's documents. And again, make sure that you're talking with your insurance agent, your management company, and your association's legal counsel to make sure that you're making good decisions on your insurance for your association, especially if you're in a difficult situation where your policy has been, not renewed. Your premium, has gone up to the point that you can't afford to have it anymore, or you're going into like a secondary insurance market, a high-risk insurance market. You want to just think through, all the problems and what the pivot is to adequately protect your association. Okay, let's talk a little bit about shopping for insurance. Again, 60 days before the renewal comes up, you're going to be receiving a notice from your insurance carrier as to whether or not they're going to renew or not renew your policy. This is a discussion you should definitely have with your management company. And I think there's an assumption, probably because we're all so busy in our industry, that if the, comes back that you're going to have a renewal of your policy, you don't yet know what your premium's going to be, but they're not going to, non-renew your policy. I think there's kind of a tendency just to sit back and do nothing. And I think as a board, you need to be proactive 60 days out prior to your policy renewing, because, if you're going to shop the rates for insurance companies, that 60-day window is like your game time. So what I typically see with associations is there's no shopping for different rates, and the management company and the board are not communicating 60 days before the policy is set to renew. And basically what happens is about a week before the policy premium is due for the renewal, the board's asked to sign a check. And there's basically no research regarding, hey, can we get a policy that might be cheaper, a better fit, more coverage, lower, deductibles. There's no research on it. You get what you get and you don't throw a fit. And because there's no time to go and research it. So really as a board, a good best practices pointer for today would be know when your policies are up for renewal. And in that 60-day window, you should be reaching out to your agent and finding out if they can, shop this and see if there's another insurance company that might be a better fit for you. It might be a broker or an insurance broker who might be doing that for you as well. Okay, let's see. What are some things to really watch carefully on insurance issues? Well, first thing I want to mention is notice. So I talked a little bit about under the Fidelity bond, notifying the insurance carrier. If you think that a perpetrator, a board member or manager has stolen funds from you. But this notice requirement is really important. It's probably one of the most important things I'm going to say here today. So if your association is aware of a possible claim that may be filed against your association and you're going to be turning it over to the insurance carrier, you likely, like 99.999% chance, are going to have a requirement under your current insurance policy to notify the carrier of a possible claim against your association. So when do we do this? So the example I gave you, if we have discovered that there's been fraud or embezzlement of association funds, you may not know how much yet, but you smell that there's a problem here and there's adequate evidence. You should notify your carrier of this, and your attorney can help you do that. If you're aware that there was a bad accident in your association, I can think of one in particular. within the past 12 months where there was a death and an association, due to a traffic accident, and there was some thought that the way that a contractor had placed a trash receptacle had contributed to that, and the association hadn't, required this contractor to move it to a more safe location. In a situation like that where, okay, there's a serious injury and, it's possible that we could be sued as an association, we should be notifying the insurance carrier. And anytime you have a situation like that, you really should be talking to your legal counsel. Hey, this happened over the weekend. Can you think of anything that we need to be doing to make sure that the situation is handled properly by the association? So I would say notify the insurance carrier of a possible claim. Number two, make sure that that dumpster, like an example, is removed. Make sure that you're talking to our security personnel and our patrols, that if they see something like this in the future, that the owner should be contacted immediately and it should be moved. I mean, just different things like that are very smart to do. Another time that you may have to notify the insurance carrier of a possible claim is if an owner says, I'm going to sue you. We hear that from owners sometimes when maybe we're involved in a dispute with an owner regarding an owner's violation, or maybe the owner isn't paying assessments or fines, or they're aggrieved by an architectural decision and they say, I'm going to sue you. That is the time that you definitely want to be notifying the insurance carrier of a possible claim. What's the consequence if you don't notify the insurance company of a claim and you're aware of it? It's possible that the insurance company will deny coverage because they weren't timely notified of the claim. So making good decisions on when to notify the insurance company is a very important skill for your board and your management company. And you should be consulting with your legal counsel and your management company and also your insurance agent if you're unsure about whether or not to provide notice. Let's see, what would be some other problem areas? Deductibles, especially for condominiums. A couple of thoughts on deductibles. So a trend that we're seeing with condominiums is, for damage claims, what associations are doing to lower the premiums is that they're making deductible really high. So let's say, you have $1 million of coverage, property damage coverage in your condominium, and but the deductible is like $60,000 or $50,000. What that means is that the association is self-insured. That means they're paying all claims up to $50,000. And then any large claims over 50 or over are going to go to the insurance carrier. So you really want to think through deductibles because there is a science to it, right? It's a game. If, you're making your deductible so high to lower your premium, what if there are 15, claims that are under $50,000 in that premium period or the year that you have the insurance policy? You may end up paying a lot more than you would have if you had just, gone with the lower deductible. So deductibles are something that there definitely needs to be some thought put into it, and discussion with your agent and your board, your management company, and your legal counsel. Another issue that comes up is who pays the deductible. First line of defense would be I'd look at your association's documents to see if there's a specific provision on who pays the deductible. Let's give an example. Let's say that your condominium, a pipe breaks. It's considered common areas. It's not, pipes in the wall, but it's not in the airspace of the unit at a condominium. So it's the association's responsibility to maintain this pipe. For whatever reason, the pipe breaks. It's not the fault of the owner. And there's significant water damage to, the unit owner due to that pipe breaking. That's typically going to be the association's responsibility to pay that deductible. And how deductibles typically work when there's an insurance claim is that the insurance company, when they're paying out the claim, They just short how much they're paying you by the deductible amount so that they know that they get paid. Let's flip it. And so at the end of the day, you may not have as much money to work with because the deductible will be, subtracted, and the association may have to make up to put that property back to the condition that it needs to be put back into. Let's switch it and say, a very common thing that we see is maybe inside the airspace of a condo, an owner has some sort of a water incident, whether the bathtub overflows or the toilet has a leak and it's inside the airspace of the unit, or the disposal or water purifier. I mean, there's all kinds of different water here, where the association is not at fault, but a claim is being made on the association's policy because, the association's policy is primary and common area has been damaged. In those circumstances, the homeowner typically will be responsible for the deductible because they're at fault, because the root cause of the water damage, a fire, could be grease fire from cooking, is the fault of that particular owner. So again, there needs to be some analysis on the deductibles at the time that you renew your policy, and then also when claims are being made. Remember that if an owner asks if there's some sort of a damage claim that they're making and they're coming to the board definitely needs to take that request seriously. If the board isn't responding in a timely manner, the owner can go directly to the insurance company and make the claim themselves on our policy, the association's policy. So you definitely want to respond in a timely manner if an owner is coming to you as a board to make an insurance claim. A couple tips to think about, one more thing I want to mention. If you have direct employees for your association, meaning like you have a maintenance man or a handyman, or, you have on-site staff, and they are not, employed by a third party, that's an independent contractor. If you have direct employees, you have to have workers' compensation insurance in Arizona. And many boards overlook this coverage, but you do need to have this coverage if you have direct employees. So anyone on your payroll, as a direct employee, you have to carry this workers' compensation insurance. It's not that difficult, but it's through the state of Arizona, so you want to make sure that you look into that and be aware that that is a requirement. Okay, let's just do some quick insurance tips, before we move into our second topic, which is safety. Know when your policy renewal is. That's a good question for your management company, and calendar that date. So 60 days before that date, you should be thinking, okay, we need to be getting together our strategy for our insurance renewal and our premiums. Make sure that you read the provisions in your association's documents so you understand what types of insurance you are required to carry as a board. Research to determine if your insurer is on solid financial ground. There are different grades for different insurance companies, like A, B, C. You want to make sure that the insurance company that you're using has a good rating. Be proactive about risk management. The best way to reduce premium costs is to limit the number of claims that are filed on your policy. Some claims are unavoidable, but other claims you may want to have a strategy that you're, paying out of pocket versus making an insurance claim. If you've had a number of large claims recently, and then you got a small claim, that may be one that the board pays out of pocket so that your insurance doesn't get canceled. So there definitely is a strategy of risk management on your policy, and your legal counsel, your management company, and your agent can definitely, provide you with feedback on that. Even if insurance coverage is in place, be proactive. We've talked about shopping the insurance coverage. If there are changes in exposure to risk, and also to kind of price check and compare what's available in the market right now. Decide what coverage you need first, and then compare apples to apples. If you are going to change insurance carriers, make sure that you ask the agent to certify the new policy coverage in writing. That statement should include apples to apples comparison, listing the coverage from the old policy the new coverage and any coverage from the old not provided in the new policy. Just so that if you are changing, insurance companies, that, you're not dropping Fidelity Insurance by mistake and not realize it. Have a claims policy, procedures, and follow them. So, oftentimes insurance claims are emergencies, especially when there's water or fire incurred. And so pre-talking about them as a board, like how are we going to handle this if this should happen, is really a smart idea, so that claims are processed in a timely and efficient manner, and that we can mitigate any damages that may occur, especially with water damage. The sooner we can get in there and get that cleaned up, the better. Let's see. For condominium owners, make sure that we're talking about and educating the homeowners in your association about what the association is covering insurance-wise and what the owners are required to carry as owners, so that they have the proper insurance as well. And when an insurance company receives notice that, hey, your policy is not going to be renewed, you need to act promptly. You need to talk with your agent, you need to talk with your management company and your legal counsel to come up with a strategy on how to best handle that difficult situation. Okay, that's it for insurance. That's kind of a dry subject sometimes, but honestly, when you give the examples and you talk about how serious issues can be if you don't have insurance right, it's something that every board really needs to be focusing on and thinking about to adequately protect them. Okay, let's talk about community safety and preventing crime and limiting liability for your association. Something that we talk about from time to time with boards is, how do we handle property crimes that happen in our neighborhood, or how do we handle it if there's been increase in, burglaries, robberies, or maybe something, really horrible in your association has happened where there's a perpetrator that's, may have attacked people. I think according to, the United States Department of Justice, a property crime is committed every 3 seconds, and a burglary takes place every 12 seconds. A motor vehicle is stolen every 20 seconds, and a murder occurs every 23 minutes. Those statistics are scary. And I think, a lot of associations don't know what to do if there is something like a crime or a safety issue within your association, because it's different from, maintaining your association. It's kind of a new issue. And so what I'd like to do today is give you some tips on how to handle it if you are seeing an increase in crime in your community, and, just know what your responsibilities are as a board. So one of the fundamental issues, regarding liability for associations when there's, crime or, injury or something like that, or property damage, property theft, is what duty does the association and its director owe to owners and residents and guests that live in an association or that are visiting an association. And the Arizona Supreme Court, in a case that was decided many years ago, applied a standard that's very similar to a landlord-tenant standard. And basically, this is the Martinez versus Woodmar 4 case. And this is kind of an interesting case. I don't know exactly what year it was, but it was when I was a much younger attorney than I am right now. So I was probably in my 20s. Now I'm 55. So this is 25 years ago at least. So in the Martinez case, the Arizona Supreme Court found the association had a duty to use care and to maintain the safety of the common areas. And so what the facts were on this case, kind of an interesting case, was a plaintiff, person who was suing the association, who was a guest of a tenant, sued the association, in this case Woodmar for Condominium Association, after the plaintiff was attending a graduation party as a guest of a tenant at the condominium complex. Sometime later, after the party, the plaintiff and 2 other guests returned to the complex's parking lot, where they found a group of local young people sitting in one of the guests' cars. There was an altercation on the property of the association in the parking lot, and plaintiff was shot in the back. Now, mind you, This person, again, was a guest of a tenant, and they sued the association. The plaintiff, his friends, and the live-in security officer recognized the group as a gang of young people from a neighboring complex that would often gather in the parking lot to take part in illegal activities. In the past, security guards had broken up this group of mischief, but because of budget constraints, the association's security guard that used to patrol the complex, for limited evening and early morning hours, had been, the hours had been reduced, so that the guard wasn't there at the time this occurred. The plaintiff sued the association, claiming that the association was liable for failing to prevent the attack, on that particular guest of a tenant. So interestingly, the Arizona Supreme Court, when this case was eventually appealed and was in front of the Arizona Supreme Court, found that the Arizona Court of Appeals mischaracterized the case. And while the association had no responsibility to control the shooter, a duty existed on the part of the association concerning the property. And the court held that any common areas under the exclusive control of the association, a condominium association has the same duties as a landlord. And what that means is that the court in this case held that the association was liable, was, responsible, and was going to be financially liable by their insurance company because it found evidence that the association knew that gangs, gathered in the parking lot and the other common areas. They knew that they were engaging in criminal activity. They were warned by their prior security guard of the need of a 24-hour patrol. They hired a second security guard to deal with this issue, but then later terminated him because of the expense of having the security guard on premises. And the association knew that other complexes had hired off-duty police officers to patrol. So the Martinez court, the Supreme Court, found that the association should be held at the same standard as a landlord, and said that the association had an affirmative obligation to exercise reasonable care to inspect and repair such parts of the premises for the protection of the lessee, and the duty extends to members of the tenant's family, employees, invitees, guests, and others on the land in the right of the tenant. So really kind of a landmark case in Arizona that, makes it a duty for boards to keep their common areas safe and free of crime. But again, it would be that, foreseeable and preventable dangerous activities on the land. That's what the association has to be mindful of, right? And so the association in this case had a duty to their owners and their guests to maintain the common areas safe from foreseeable dangers. And so the facts were kind of, unusual in here because they knew about the dangerous gang activity, and the board ultimately reduced the security coverage that they had in their community. So in light of this case, what should associations be thinking about? What are some practical considerations so that you can limit your liability? Some on-site suggestions that we have for you, install controlled entry systems. So if you have guard gates, electronic gates, telephone entry systems, those are all helpful in keeping your common areas safe and free from crime. For some associations, budgetary constraints are not going to, be able to allow you to do that. But be careful. Like if you're one of those associations that maybe you have a gate access to your community, but the gate is always broken and it's always open, that is definitely a liability. You need to get the gates working and having in operable order, because there's an expectation that a gate is going to, provide controlled access so that not just anyone can come in. You may want to consider having a security patrol. And this could be in the form of hiring off-duty police officers, a security company. You also may want to consider having like a neighborhood watch group. So there's different levels of money that you may need to spend. And again, these are kind of suggestions I'm giving you in the event that you're seeing increase in crime level in your association, like you're hearing reports that, hey, people's cars are being broken into, or that people, leave their garage door open and now things are being stolen out of their garage. You know, one thing that I think is a great suggestion that when I attend board meetings, sometimes I see this, or annual meetings, I see this. The board does like a safety and security report, and they'll have like a local police officer from the precinct that's closest to the association come in and talk about, crime in the surrounding areas, and maybe even a crime analysis of what's going on in your community. And they can talk about what are some things to prevent theft and crime. So the most common things that I hear would be remind owners to close your garage doors at night. Remind owners that if you're out of town, use, different battery operated lights or, different devices so that lights turn on and off. So it looks like somebody's home. Don't leave valuables in your car that's parked in your driveway, because that's going to be something that's going to be enticing to a criminal. They're going to break into your car to get your purse or your laptop. Some other things that boards do are they also install surveillance cameras on the common areas. This is kind of tricky because, most of the time that camera isn't going to be monitored 24/7. And so, you don't want to give a false sense of security to your owners. If you're putting up cameras, we see a lot of associations put cameras up at pools, and that's not monitored 24/7, but they do it so that if there's damage to the pool, they can go back, rewind it, and see who caused the damage. So that's kind of a sticky wicket because, even if you have the cameras, you may not be able to identify who the person is that did this if they don't live in the community. And also you want to make sure you notify the owners that, hey, this isn't, monitored 24/7 by somebody. So in the event that there is, something serious going on, you need to call 911. Having proper lighting in an association is also a deterrent for crime. So using motion sensors, making sure that lights that have burned out are properly replaced in a timely manner. That does provide an extra level of, coverage in that maybe a criminal is going to be less likely to come into your neighborhood because it's really well lit. Reducing the size of shrubs, particularly in front of front windows and other areas, also can eliminate hiding places for criminals. There are some programs that an association can implement that will be helpful to, limit crime and liability for associations. Creating neighborhood watch groups, security patrol in your association, having these signs in the windows, and you can work with your local police precinct to help you set those programs up. And it's all volunteers that run it, can be a deterrent to criminals. Having, different programs that you may set up in your association to raise awareness, like a bicycle registration program, an out-of-town watch program, having a bi-monthly newsletter or a newsletter when you need it that just kind of talks a little bit about reminders to keep your garage door shut, or letting people know that, hey, there have been a few incidences in our community. Please be aware of your surroundings if you're walking alone at night, etc. Also, putting neighborhood watch signs at the entrances to your community can be a deterrent to criminals, and have those well lit so that they know that we have these type of things in place. And last but not least, some suggestions for the board. Don't misrepresent the quality of the service. We don't want to overpromise and underdeliver. So be honest with your homeowners. This is the type of security system that we have in place. We don't have 24-hour monitoring of the cameras, etc. Create a crime prevention handbook for your association if you think that's something that you need. There's a lot of crime, maybe suggestions and tips. Have a plan of action if problems develop. Implement additional security measures and notify residents that they need to take steps to protect themselves if things are, occurring in your neighborhood. Don't reduce security without talking about it with your legal counsel, your management company, because like we saw in the Martinez versus Woodmar case, that really was a problem in that lawsuit and created liability for the association. If you are going to reduce security for your association, maybe because it's no longer necessary, just make sure you're notifying your residents of the board's policy change on that. And then most importantly, obtain adequate insurance. So if something does occur on the association's property, we have adequate coverage for the association. And really these, suggestions, there are cheat sheet. We have a great cheat sheet on this topic. You may want to ask board, take a look at these issues and suggestions that we have in that cheat sheet to help you create a more safe environment for your community. Today, we had over 180 viewers at our peak during the seminar today. So that's amazing, really good turnout for our class today. We have one in-person Scottsdale class coming up this month that I want to just make sure that we let you know about. The city of Scottsdale is doing in-person classes right now. And I'm going to be teaching a class on Thursday, September 18th, in person, between 1 and 3 o'clock. You're, of course, welcome to attend. And it's at Mustang Library. You can find out more information on it on our website. We're going to be talking in depth about the 2025 legislative update and how to effectively work with your community manager and your management company. And again, that's an in-person class that I'll be teaching between 1 and 3 o'clock this Thursday at Scottsdale Mustang Library. We also have another in-person class that we're going to be teaching for Scottsdale on Wednesday, October 8th, between 1 and 3 p.m., again at Mustang Library. And this is going to be practical strategies for aging HOAs and condominiums. Like, where do we go from here? Our association has deferred maintenance. We are looking at a big special assessment. We've got a lot of capital improvement projects we need to do. We're going to be giving advice on aging associations. How do we get back to, having things maintained, and how do we turn this around, basically? Okay. Also, there is going to be our First Fridays. Don't forget about that. Can't believe it's already September of 2025, but our next First Friday is going to be on Friday, October 3rd, between 9 and 10 a.m. First Fridays is your chance to ask one question at no charge, and we answer the questions in rapid fire. You can find out more information on that on our website, where we're going to be sharing information with you now. And then last but not least, we have our October class, which is class number 10 for the Neighborhood Services HOA Academy. We teach that on Zoom and Facebook Live, starting at 11 a.m. It's always the third Tuesday of every month. And we're going to be talking about assessments, how to get people to pay assessments, and large capital improvement projects. So that'll be a great class on virtual class on October 21st. So thanks so much, everybody, for being here today for our class. We look forward to seeing you at future classes, and we appreciate you caring about your association and wanting to make it better. So have a great rest of the week, and see you soon.